Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
All right. Hello again, and welcome to another exciting episode of Empowering Plans. Today, I'm your host, Jen McCormick, and I have with me here today Nick Bonds. We are so excited to be here. Nick, I think this might be your first time doing a podcast. Is that true?
This is actually my second time doing the podcast, but I'm happy to be here commandeering the Empowering Plans podcast alongside you, Jen.
Awesome. Well, this is our first time doing one together then, so I think that makes it even more special.
That is true. That is true. A new era
All right,
of the podcast is dawning.
Yeah, this is actually a very exciting episode, and I would be remiss if we didn't also introduce Pat Santos, our producer, who is here with us today, making all of this possible for everyone to listen to. So we thank him very much for his ability to kind of produce everything appropriately. But the topic that we have today is a pretty exciting one, don't you think, Nick?
Oh, so exciting.
So it has been something that has been talked about on other FIA media and webinars and podcasts, I'm sure, in the past. But today we thought this needed a little bit of extra attention because this is one that's moving along pretty quickly, actually. There's been a lot of recent happenings and developments when it comes to 1557 under the ACA and the Bostock case and some other regulatory action that we're expecting to see now and in the future. So this is getting a lot of attention for everyone to make sure that they are aware of what the implications are going to be for employers and for plans and for individuals. So this is a really important thing for everyone to really understand the significance all the way around for all those involved. Nick, is there anything in particular for this topic that has really come to be confusing, you think, or a lot of questions that you think that we're getting? Or do you think maybe the best spot for us to start would be the beginning? I know since this has been going on for years at this point, the development, the changes, the modifications, maybe our listeners would appreciate a little bit of background so they understood what it was exactly that we're talking about. You want to kind of kick us through what has been going on since the beginning of 1557 under ACA?
I would love to, Jen, absolutely. We have actually been getting quite a few questions about some of the developments our plans and our groups that we work with have been seeing around Section 1557. And the thing about this is it kind of goes all the way back to the beginning of the ACA. It was a part of the ACA originally when it took effect in 2010. There was some back and forth through the Obama years trying to implement the regulation, which sort of culminated in the 2016 regulation. In 2016, HHS implemented a rule kind of applying and interpreting the regulation to basically say that individuals can't, on the basis of race, color, national origin, sex, age, or disability, be excluded from participating in or be denied benefits of or subjected to discrimination in health programs and activities. They sort of grappled for a while on how to define sex discrimination, but they settled on defining it as discrimination on the basis of pregnancy, false pregnancy, termination of a pregnancy, recovery, childbirth, and then the really tricky pieces were sex stereotyping and gender identity.
Yeah, I think that has been something from 2016. As you know, one of the things that we are often helping plans and employers with is questions relating to their benefits, particularly their plan documents. So back in 2016, with all of this confusion and trying to figure out whether or to what extent exclusions or provisions were allowed or taglines or requirements were necessary to be included, what did people need to do in their documents 4 short years ago?
We often advise people to be careful with their exclusion language and with their benefit design to make it as neutral as possible, especially with some of the components that can get especially tricky, things like exclusions for transgender services or sex change operations. Things like that can get dicey pretty quickly under the rules prohibition against discrimination. So we were always very careful advising plans in that arena. The rule also imposed a few requirements that plans have assistance available for individuals that either had disabilities or limited English proficiency. LEP. And that's sort of where the famed notice and tagline requirement came from, which was essentially a section that we would tack on to a lot of plans, giving notice of availability for plan language in different languages available to plan participants. So that added a little bit of complexity and a little bit of length, certainly, to a lot of the plan documents we worked on.
So this meant, what you're saying is, back in 2016, we said everyone who was subject to this 1557 regulation, which at that time was broadly or more broadly defined than what I'm sure we're going to talk about in a minute, and the scope was narrowed, that those entities who were receiving some sort of that federal assistance were required to make modifications to their plans if they currently had an exclusion or they didn't have the taglines or the necessary requirements within the notices within their plans. So we said, make sure that you are following the rules based on our conservative view at this time. This is what you need to do to comply in 2016.
Right. The tricky thing about the previous rulemaking is that it essentially required a plan that, to any degree that it received federal funding, was a covered entity under the regulation, meaning that a plan that received any amount of federal funding through HHS had to comply with the notice and tagline requirements and the other non-discrimination provisions of Section 1557.
So then what happened on June 12th? What changed?
So on June 12th, we got an exciting new rule issued from HHS. And the big deal here is it dramatically narrowed the applicability of the rule. It no longer defined covered entities as those that any portion of which receives federal funding through HHS, but it very, very specifically applied to health programs and activities only to the extent that they receive that federal financial assistance. So if they received just a portion of that funding, they only had to comply to the extent that their plan was receiving that funding from the federal government, basically. Now it only applied to an even smaller cross-section of employers.
So this meant essentially that all of the things that we had suggested potentially in the past that should be reviewed, considered, or modified, this new updated HHS final rule was modifying that and saying, just kidding, this is a much smaller pool of individuals. This is a much smaller pool of modifications that are going to be necessary in the first place.
Essentially, yeah, that's sort of what HHS came out and said. HHS looked at the previous rule and also looked at a lot of the litigation and a lot of the arguments around the rule and whether it was going too far. And they sort of reasoned that the previous regulations were imposing too much of a financial burden on employers. So they retooled the rule, they narrowed its applicability, and they removed a lot from it, actually. They took out a lot of the definitions, they took out the very, very explicit interpretation of gender identity and sex stereotyping. They also took out the full notice and tagline requirements. They kind of gutted the rule in a lot of ways. They did it under the rationale of trying to make life easier for employers, essentially.
But even though this rule was arguably supposed to make it easier for employers, that didn't change the fact that even dating back to 2016 and previously, that there was still the concern or the consideration that employers not subject to 1557 could still face some employment discrimination issues potentially.
That's right, yeah. The non-discrimination requirements don't apply just to your healthcare plan. They apply broadly to a lot of different aspects of employment, which was actually the Monday after the HHS announced this new interpretation of the final rule. The Supreme Court announced a decision in a case called Bostock v. Clayton County that was sort of interpreting those non-discrimination requirements in the broader employment sense.
So this is creating a conflict a bit in what it is that an employer is supposed to do or what it is that they are supposed to be offering for their plan. So based on my understanding of the Supreme Court ruling here is that this is more narrowly defined, specifically for Title VII purposes and employers as it relates to employment considerations or employment privileges and not necessary to their plan. Is that right?
Not strictly to their plan, but the Supreme Court was pretty careful in their ruling to say that they were only looking at the applicability of Title VII and not other federal regulations. But Title 7 applies a non-discrimination requirement in the terms of employment, which includes things like compensation, hiring, firing, and the provision of employer-sponsored healthcare benefits. So in sort of a roundabout way, the Supreme Court decision has a lot of implications for employer-sponsored plans and kind of threw a nice shot of chaos into the simplification that HHS is trying to offer with their reinterpretation of the rule.
So there's not a nice harmony going on with these two situations between the Supreme Court case and the updated final rule from HHS.
You could say that. You could say that.
So you think that it couldn't get any more complicated. So right now we have plans that have questions about what it is that they can do as a result of the Supreme Court case. So what had happened over the weekend, they were thinking about maybe pulling back or making these modifications to their plan. And then all of a sudden the Supreme Court case comes out, and then we give it a month, and then something else happened. What happened on July 20th?
Well, so come around to July, we get an announcement that Maura Healey, the state attorney general from Massachusetts, along with attorneys general from, I believe, 22 other states, have jointly filed a suit against HHS and the Trump administration in federal court in the Southern District of New York. They are suing to block the new rule interpretation that HHS announced. They are arguing that it was arbitrary and capricious, that it was violating the Administrative Procedure Act, everyone's favorite rulemaking law, and that it would basically cause a lot of harm to transgender individuals, people with disabilities, people with limited language efficiency in the midst of this global pandemic that we're facing. So the rule itself was actually scheduled not to go into effect until August 18th. Between the state attorneys general suing the federal government to block this rule and a few other activist groups like the Human Rights Campaign, groups like Lambda Legal, who had already filed suits to try to block the new rule and the new interpretation of 1557. It's looking likely that the reinterpretation of that rule may get completely tangled up in litigation, in possibly injunctions. We don't know yet. We can't say for sure, but it seems possible at the very least that the legal proceedings might tie up the effective date of this rule, which makes it really difficult for employers that were looking on changing their plan designs or modifying their benefits. It makes it tricky for them to try and rely on it. So what we like to advise is don't be hasty. Let's take a minute and see kind of where the chips are going to land, and we'll figure out if and how it may be a good idea to make any benefit changes. But in the meantime, the Supreme Court decision in the Bostock case, that takes effect immediately. And that case basically said that the way HHS interpreted the language in the statute on the basis of sex, it pretty much says that that was incorrect. And a lot of these groups that are suing are using the Supreme Court's argument from Bostock on how to interpret that language on the basis of sex and how to interpret sex stereotyping and gender identity. A lot of them are citing to the prior Supreme Court decision that came out, again, just days after HHS announced this rule. They're using all of that to bolster their arguments against HHS. So it's a pretty heated battle right now between the different sides.
We have employers and plans that are coming to us and saying, help me. We're getting closer to our renewal, and we need to make sure that we understand what our obligations and duties and responsibilities might be, and trying to sort through all these different rules and regulations. And your response to them is, don't be hasty. So are we saying that at this point, we need to be sitting tight before we make any of these changes because we don't know what we don't know?
Right. Our conservative advice a lot of times is there are a lot of unknown unknowns here. We don't know how the legal proceedings are going to go. There's also, a big election coming up that could potentially throw a few wrenches in the administration of the ACA, let alone another Supreme Court case that could reinterpret the ACA itself or potentially invalidate it completely. So there again are a lot of unknown unknowns. If you have questions, please reach out to us before you do anything drastic. We can look at your plan, we can look at your situation, we can talk you through available options, things to consider. But that's sort of my 3 words for this podcast is don't be hasty.
All right, I like it. So in summary here, this is a complicated matter when we're trying to figure out the implications for employers and for plans as it relates to 1557, the HHS rules, the new Supreme Court cases, or other litigation that's going on in the various states. There's a lot to unpack here and a lot to figure out. So we will continue to monitor what is happening to make sure we are doing everything we can. So look out for plans and employers and advise on next steps and considerations. So with that, I appreciate everyone joining us today and listening to this exciting episode of Empowering Plans. We appreciate everyone, and thank you to Nick and thank you to Pat, and everyone have a great day.